17 years of expertise in high. I think admin team has been done with recording. So let me start again. So I'm Charu Nayak, and the team into legal world is delighted to introduce Miss Kathleen, an internationally certified mediator, trainer, consultant, author, and advocate with over 17 years of expertise in high conflict mediation. With nearly 1,000 mediations and an exceptional 95% agreement rate, she has trained and mediated across the US. She has taught the prestigious 40 hours basic mediation training and worked extensively with US courts. Ms. Leedy has also coached students at Harvard, MIT, and Holy Cross competitions, and she has continued as a published author and global ADR advisor. Although Ms. Kathleen currently works in the United States, her influence and guidelines travel far beyond borders. From India, we extend our warmest respect and heartfelt admiration for her dedication to mediation, her inspiring career, and the knowledge she continues to share with learners across the world. Hi, ma'am. Huge love from India.
Thank you so much, and much love back from the United States. I actually live in Los Angeles and here in West Texas, my office.
Means a lot, ma'am. Means a lot. It's lovely to see you.
Thank you. It's nice to be here. Thank you for the kind invitation. Let me see if I can share my screen, first of all. And let me also put my slide deck into the chat as well. So everyone, you can have it. I'm going to share it right now to the chat. Can everyone see my screen?
Yes, we can.
Nice. Let me unshare very quickly, and I'll put this into the chat to the slide deck. And one moment, please. Let me make this bigger. There we go. Where's my chat? There's the chat right here. Okay. I'm putting the slide deck. You can use the slide deck any way you'd like to. I always share. When I'm working with students, I always share and never charge. All right. Let me share again now, and we'll start working with this. So this is a wonderful topic. It started out as a topic. Let me make this bigger. Make this bigger like this. There we go. And let me start the slideshow, which doesn't want to start. Okay. This one. Let me unshare again, stop sharing. Let me go to my share again. Share my tab one more time. Does everyone see how small this looks? That's my problem right now, slideshow. I'm clicking on the slideshow and it's not letting me get bigger. Let me try this. Can everyone see that okay now? Just give me a thumbs up if everyone can see that. It'd be wonderful. Thank you. Thank you, thank you, thank you. So this is a really interesting topic that I've been asked to share about strategies for mediation within the international commercial arbitration. So kind of a combination. I was asked at first to talk about mediation, and I would be happy to as well. And also, let me talk briefly about commercial arbitrations. Arbitrators can stop or stay the arbitration process for parties to go into a mediation venue for particular issues, maybe only one issue, maybe two issues. Something, somehow, some way, the arbitrator has decided that I want these people to go sit at the mediation table where they can have more freedom of discussion and talk it out amongst themselves instead of the arbitrator or the 3-panel arbitrators making decisions about a particular topic of the arbitration. So when arbitrators seek to have people in the arbitration have a fully empowered conversation, especially at the facilitative mediation table, that's what we're going to learn how to do today. Because no matter what the reason is for a mediation, the process is the same. And the process, according to how you run it with your mediator style, your mediator confidence, your mediator courage, is you. You are the most important person at the table because you're being yourself, it's not me, it's you. And you are running the process. When there's a state arbitration, or whatever the purposes are, it is very important in the beginning of the process to acknowledge that we have left. No, I can't move my screen. Okay, let's see what's going on here. Let me stop this sharing. Let me go to my slide deck. Okay, there it is. Go back to here. I may be asking the team here in India to, let me just go to the window, to share my slide deck as I move through it, because it doesn't seem like this wants to do well. Yeah, there it is, small again. The India team, are you able to put this into and share your screen instead of me sharing mine? Because my screen sharing right now is not allowing me to move forward in my slide deck. Is that possible? Hello? Hello, hello, hello. I need a little assistance here, please.
Yes, ma'am.
Are you able to put my slide deck that I sent to you into, or that's in the chat, into your shared screen and move through the slide deck according to when I tell you to move?
Okay, ma'am. I'm sharing my screen.
Let's see if that works, because I do not know why I cannot. Stop my sharing. Hello, can you share my slide deck from your side, please?
Yes, ma'am. Please wait for 2 minutes. I'm sharing my screen.
Thank you so much. We're waiting on my slide deck to be shared by someone other than myself and move through it.
Is it okay, ma'am?
If it's large enough for everyone to see, yes. If you can just move to number 2, that would be great. If you could put it into slideshow as well. See the slideshow up on top? If you can hit slideshow, it'll make it larger. If you take your cursor over to the right of my face, there you go, hit that. There we go, thank you so much. It's very important when they stay in arbitration for mediation to happen, the arbitrator And the process, you see, is very adjudicative. It's on the formal side of lawyering. It's on the formal side of finding justice for people. It's next to court. It's next to litigation. So when there's a state arbitration, commercial arbitration, for whatever the reasons are, the arbitrator will let you know as the mediator what you can talk about, what can be discussed, what can be resolved. Sometimes the decision at the mediation table is the decision the arbitrator will honor. So if we look at mediation, we see that mediation is more consensual. It's more informal. People have a fully empowered opportunity at the table to be able to resolve their differences. And that's very important because of the fact that your emotions can speak, your facts can speak, your essence is at the table, and you have a voice at the table, especially in the facilitated mediation style, which I love to practice. So you can see where mediation fits in here on the left. Next slide, please. And because of that, us being more in the left, we are following a process that journeys into the unknown. We are running a process. Process equals structure plus flexibility. The unknown is flexibility. What people are going to say is the unknown at your table about a particular subject. So it requires you to be so present. It requires you to know your style as a person. It requires you to have confidence. It requires you to be able to take courage moments as helping people preserve and create new meaning. It takes your confidence to ask a difficult question. It takes your confidence to chase exploration of the past. Your confidence, your courage, as you also move forward in the process. As you move closer to negotiation of the decision, the arbitration table has given you a chance to pursue with people. So you're journeying into the unknown, which is very exciting. And mediation is not about taking things from people. It is about offering a solution to someone and the other person accepting that solution. That's the whole difference between mediation, facilitative mediation, and negotiation, everything else like that. It's offering and receiving, not giving and taking. Next slide, please. This offering and receiving and sitting in the unknown with people requires your full attention, your undivided active listening, to listen actively. And the way that then we also have to prove that we're listening actively, because active listening requires us to prove. It's our summary of what we've heard that makes us specialist facilitated mediators. That's what the arbitration process didn't hear. It didn't hear and it didn't reiterate. It didn't summarize what people are thinking, what people are feeling, because commercial arbitration processes are about the language of the contract. Well, here now we're beyond the language of the contract and we're more into the language of the contract than the arbitrator can actually pursue as they align themselves with the rule of law. As lawyers, arbitrators, and barristers align themselves with the rule of law, this mediation table is larger than the rule of law. So how we are larger is we prove what we're hearing. When you summarize back what someone has said to you at the table after they've answered your question, there's different ways of proving active listening. Reiteration summary is when you repeat every single word the person said, at least their keywords. Reiteration summary has 100% accuracy. Reiteration summary is protecting the culture of the people, the person that's talking to you. I use reiteration summary all the time because I'm protecting the culture of the words that were used by them. And when I say it back to them, if they want to correct themselves, they may. They're correcting themselves, not me as the mediator summarizing them. Or they're adding to something else they want to say and didn't say. It's one thing to talk to the mediator. It's another thing to hear the mediator talk to you using your own words. Very powerful tool, reiteration and summary. Another way to prove that you're actively listening is to paraphrase. Paraphrase is when you substitute out a word and replace their word. If they say they're angry and you as the mediator say, you're frustrated, that's your word. It wasn't their word. And I don't stay away from emotionally charged words, because neuroscience tells us when I say someone's angry, when someone told me they're angry and I say you're angry, that starts to validate and acknowledge them, so the tension comes down. It doesn't make it worse. We think as normal people it makes it worse. No, neuroscience tells us validation starts to calm people down. So I protect the culture. I don't paraphrase right away. I don't replace people's words. When you paraphrase, summarize, you're losing 100% accuracy, but you may capture the spirit of what the person is saying to you when you substitute out your own words. And what you also are doing, you have to be ready to be corrected. They may say, oh no, I didn't say that word. I said angry, I didn't say frustrated. So it's a matter of how attached people are to their words, how those words project their culture of meaning for them. Reframing summary, proving again you're listening to someone talk to you, is when you come at the story from another angle and you force them to view their words from a different perspective. It takes a second for them to catch on, to see if they agree with your reframe. You've changed their story. Maybe you've made their story more positive. Maybe you've made their story more dramatically negative. That's what I like to do when someone's very, I'll use the word stubborn at the table. I dramatize their stubbornness with a more negative reframe, and I take them out to the end of themselves as the mediator. So reiteration, paraphrasing, reframing, and transition statements and attachment. When people say words, you want to attach those words to them. When Kathleen, when you said this, this, and this as your mediator, it seems like, sounds like, looks like, feels like, these are all transition words. As your mediator, seems like, sounds like, looks like, feels like, I'm guessing. I'm supposed to guess. I can guess, because even if I'm wrong with my guess, is I'm transitioning them and moving them down the process. I'm going to be corrected. And even if I'm wrong, they're going to say, no, you're wrong. This is what I meant. And I'm going to say, thank you for that correction, to get my rapport back, because I made a little mistake. When I guessed, it's okay. You can guess as a facilitative mediator. And you use these words. We've got words on paper. We've got words in the airwaves. We only have words. So you use words to help people understand themselves better. You are a lighthouse shining your light on their conflict. Your words are for them. I also use transition statements as I'm leaving stages that I'll talk about in a little while. And I also use transition statements when I say thank you. The brain likes to hear thank you. Something in the brain happens when a person hears thank you, when a person hears gratitude. Something in the brain clicks. It's pleasurable for the brain. And so all these transition statements and words, thank you, let's move on to the next stage of the mediation. All these words are the golden glue of the mediation process, which the arbitration process doesn't have. Can we go to the next slide, please? We are in the human people business at the mediation table. That's why sometimes an arbitrator will give us this piece of the arbitration that's difficult for everyone. Can we move over to slide 5, please? So we speak differently because we're always proving that we hear you. It's our superpower. Narration is our superpower. And this is how we speak. These are some of the phrases you can start to memorize. And even in your own personal life, someone's upset with you. Well, let me make sure I hear what you're saying to me right now, is what you can learn to do instead of being reactive. They're reactive to you, you're reactive back. That's not mediator skills. And you can learn mediator skills and bring them into your personal life. So this is how we speak. I like to call it mediator speak, the way we ask questions, the way we explore more into the process that the arbitrator could not do. The arbitrator's there to gather factual information. We get to ask people how you feel on a scale of 1 to 10. How much does this matter to you? We get to do that. This is our superpower as mediators. We get to speak this way to people. Slide 6, please. So within this process that the arbitrator has given to us we still have our own process that we fit people into. Now, if an arbitrator has given us something from an arbitration, the commercial arbitration that we must resolve at the table, step 5, setting the agenda, we don't have to do that. So we piecemeal our process to help the arbitration move forward. We don't have to, our agenda is already set. We've been given the task by the arbitrator. So in the beginning, when I welcome people in stage 1, goal 1, and as I move to goal 2 is where I say, this mediation is for purposes of a state arbitration. This mediation is for purposes of handling these topics from an arbitration. So right there in goal 2, our agenda is already set because the arbitrator has given, this is what we want you to fix, Kathleen, or see if you can resolve, Kathleen, at the mediation table. So we take our 7-step process and we break it up to make it work for the situation that we're in. And we go into, instead of the parties' opening statements, we're now having the parties' opening statements about one particular part of the arbitration that I've already said, this is our agenda. So I've put goal 5 into goal 2 because we already have an agenda. So this is how you can piecemeal the mediation process for the arbitration dovetailing that's happening right now in this training deck. Slide 7, please. Remember, the arbitrator is going to craft the final agreement, but within the piecemeal of that agreement, a piece of the mediation process is in there. So we now have to explore. Facilitative mediation, we do not go straight to negotiation. We explore as we build bridges between me and you. You're my client. I'm going to build bridges between me and you, and I'm going to explore more about this past issue that's been brought to the mediation table from the arbitration table. And after I explore and get the background of the story of why it means so much to you, then I'm going to disrupt it. I'm going to reality check it. Even though I'm empowering you and you're still getting recognition, autonomy, agency, I'm going to reality check your information because I need to rubber band stretch your thinking beyond your own perceptions because you're at the arbitration table with other people. Ultimately, the facilitative table undergirds you and builds bonds of recognition, empowerment, autonomy, agency, security, status, affiliation, to then make you strong enough to give up your power to come into community and resolve issues with others. That's what the table is actually doing at its very deep essence. So this reality checking always happens before negotiation. Slide 8, please. And the way that we talk to people, the parts of people, is we dive into what's the logical reasoning of this for you. This is called the 3 appeals, and you can rotate with these 3 appeals. This is Aristotle, by the way. When you appeal to someone's logic and sense of reason, you can only do that well if they're not emotionally upset. Because the back brain that gets emotionally upset and the front of the brain that makes decisions have a teeter-totter relationship. When the back brain is upset, the thinking ability is always low. When the thinking ability is high, the back brain emotional tenor is quiet. They're always an opposite from each other. They're never in the middle. They're like always some relationship of high-low. So the logos is only talking to people logically and with reason, which is the arbitration process, is only available when someone is not upset. If someone is upset, I will start to talk to them in the logos, appeal to their logic to start to get them calmed down by saying, please make a list. I'll give them a job to do within the logos to help the emotional pathos calm down. If speaking to someone logically doesn't work, then go talk to the emotional side of them, appeal to their emotional side. Say, hey, what are you really feeling about this on a scale of 1 to 10? Try to get out the emotional because of the fact the logical appeal isn't working. Or you can go to the persuasive, you can go to the ethos, the practices, or the value, their practical experience, their work professional experiences, their life experiences, and talk to that side. So we cycle within the three appeals at the mediation table. And you can have a balance of those three appeals, but I hit hopscotch. I jump from one to the other. If one isn't working, then I'll go to the other person. Well, logically, this all makes sense. And that's all I can get from someone. Then I'll say, so then put the logic aside. How is this feeling for you? How is the justice at the table right now feeling for you? Justice has a feeling. Injustice has a feeling. When your parents or caretakers blame you for something you did not do, the injustice has a feeling. Justice has a feeling. We pay attention to this at the facilitative table. Slide 9, please. And we use a SMART goal. And because the agenda has already been given to us by the arbitration process, we already have an agenda item that's specific, measurable, attainable, relevant, and timely, because the arbitrator will tell us this is how much time they have to figure this out, Kathleen. We make sure that at our own mediation table that our agenda item is also SMART tested out. SMART testing comes from education, pedagogy. And the agenda from the arbitrator is going to be specific. Our agenda as mediators is usually 3 to 5, 1 to 3 words, neutral words. Neutral words that don't make people get mad when they read them, when they look at them. Remember, words on paper, words in the air. That's what we're dealing with here. Slide 10, please. When we develop an agenda that's not coming from the arbitrator, when we're setting our own agenda, we hear agenda pieces and parts in their opening story. And like I said, we take all those words and we reduce it down to 1 to 3 words that are not inflammatory words. If somebody wants 5 million USD and the other person's offering 250,000 to settle, I'm not going to put 5 million on the agenda versus 250,000 to settle on the agenda, because every time they both look at that, it's going to be inflammatory. I'm going to put the word monies, plural, not money. They both are talking about money, monies, plural, as an agenda item. And this is how we determine our agenda items. And then we also ask people, do you have anything else to add to this agenda? The agenda is part of the autonomy and agency of people being able to talk clearly to each other at the table. And then we have a speaking order of the agenda as well that can be important to people. So if you have a hard time figuring out the speaking order, an arbitrator gives you 3 items, stays the arbitration, gives you 3 commercial items to discuss at your mediation table. You may ask people, you may want to ask people, what's the least important here to all of you? What is the agenda item that you want to talk last about because it upsets you the most? You want to find out the speaking order of the agenda because that has a justice feeling as well. Justice always has a feeling at your mediation table. Justice always has a feeling with you and them as the mediator and them as the parties at your table. They're always going to have a feeling with you. And we want it always to feel good. That's why we give autonomy, agency, and plus we're a neutral. So you're making the decisions about your life. I'm running a process, but you are making decisions about your life. That's your autonomy. When I ask people to write down brainstorming solutions, I'm forcing more autonomy onto them because now I'm asking you to write. Slide 11, please. Writing is forced responsibility. Because as we approach negotiation, those compromises, those agreements that the arbitration is letting the mediation table decide, those are those people's lives. You need to start write down your brainstorming solutions. This is your life. You're going to be writing. I'm not moving into your house with you, helping you live your life. I'm helping you with this process. So now when I get through the disruption of the reality checking, when I move then to negotiation at my table, I'm backing away from you. I'm going to make you more autonomous. We've been talking. You've been talking to me. I've been talking to you. You've been talking to me. I've been summarizing the words to you. I've been making sure your words in the air matches the words on paper. I'm making sure I have agreement between what you say and what the paper reads. And now I'm adding another tool. You're going to write. I'm starting to back away from you now a little bit because your negotiation is not with me. Your negotiation is with the other person at the table. Them. I'm now building a bridge between them and them, which means me as the mediator, I step back. As the facilitative mediator, I step back. And now you're writing brainstorming solutions. You're writing down an actual offer that you want to offer to the other side for negotiation purposes. You're writing this down. You're not talking to me anymore, and I'm not talking to you about it until after you write. After you write, then I will come talk to you about it. And use my disruption tools, yet again, to poke holes into your brainstorming if I see there are any missing pieces in your brainstorming, and I'm going to smart test your negotiation offer. So this balance, this mix of all of this fosters a readiness, a compromise for negotiation, because negotiation is a bridge between them, and people have to come to agreement. Number 12, please. Next slide, please. Mediation negotiates from clarity. Mediation negotiates from is all understood, is all accurate. Now you can start to brainstorm solutions. Negotiation is actually a strategic discussion that happens with a lot of lawyer-type mediations or advocate-type mediations. You go straight to strategy. Facilitated mediators, we don't use negotiation techniques right away. We can get an agreement with negotiation of all the clarity at the table, not using negotiation tactics, which is coming up next. Next slide deck, please. Next slide, 13, please. So we are very, again, smart gold with our actual offers of negotiation. Please write down an actual offer. And we go into those offers before we send them over to the other side for negotiation. We make sure that offer is specific, that offer is measurable, that offer is attainable, that offer is relevant, that offer is timely based. We are smart testing the offer not only for the person that's giving it, for the person that is receiving it. So we make sure we ask all these questions, make sure all these parts of the offer, these 5 parts of the offer are intact before we take it over to the other side. This is the facilitative table. This is what we do that's different. Next slide, please. Thank you. These are negotiation tactics, strategies. Package, trade, leveraging, high-low, walk-away figure, mediator's figure. These are negotiation techniques and tactics, strategies of building a bridge between them and them. So that at the mediation table, if my clarity doesn't build the bridge, then I will move into negotiation tactics, whether people are together or whether people are in caucus, separate private sessions from each other. You can still run through all of these techniques, strategies of negotiation versus the clarity of negotiating from clarity and accuracy at your table. Next slide, please. And this, crafting the agreement, then becomes easier. I start crafting my agreement right in the beginning. I interrupt people's conversations and I say, did I hear a partial agreement? Before we even negotiate, I have a living rough draft agreement. I get pre-agreement and I read what I hear in the conversation, I'll read it aloud so people can hear it. My final agreement gets wordsmith. I read it aloud and I say to people, and this is a very powerful tool to use because mediators, we pick up tools, we put them down. These are all tools. I say to people, I'm going to read aloud your agreement, your pre-agreement. Please stop me when you hear a word you don't like. Every word has a justice feeling. Injustice or justice, yes or no, on a scale of 1 to 10. Somewhere in there, every word is going to be okay, really okay, not okay at all. So I have people wordsmith the agreement when I read it out loud, and they do stop me, and we do go into the dictionary, we do go into the synonyms of antonyms, and we do find the word that feels right for them. This is how I craft my agreements. My crafting agreements actually starts in the beginning of my process because I'm listening to words in the air, and I've already read words on paper. So I say, this is my rough draft agreement. I may be interrupting your conversation to write something down quickly, and I'll be speaking it out loud. Did I just hear a partial agreement here? Is what I like to say. Next slide, please, as we come to the end of our deck. Okay, and questions? Around that little bit after the hour mark of me presenting.
Hi, students. Students, if you have any questions, please raise your questions.
Yes, please speak out your question. Thank you.
Good evening, ma'am. Thank you so much for having today's session.
Mhm.
Ma'am, I would like to ask you that on the 13th slide, 14th slide, the last three words, BATMA, MLAMA, what is the full form? Means what is it saying?
Let me go to the slide. Thank you for asking. On the bottom, on the slide deck, you have the BATMA, the WATMA, and the most likely. So the BATMA is if the negotiation mediation table fails. It's always the true meaning of the BATMA and WATMA is meaning the best alternative to a mediation agreement, the best alternative to a negotiation agreement. This is a great question. Thank you for bringing it up because I just passed right over it. Thank you so much. If the table fails, when you walk out that door, what is the best thing that's going to happen to you? The BATMA, the best alternative to a mediated agreement. On the far right of that, what is the worst thing that's going to happen to you in your life as soon as you walk out this door if the mediation table fails? So if it's a state arbitration, the way we would use this is, what do you think the arbitrators, what's the best thing that you think the arbitrator is going to be able to do for you if this mediation table fails today? The BATMA-WATMA is always based on if the table fails. The BATMA-WATMA isn't the best alternative to your case. The BATMA-WATMA is the best alternative, the worst alternative if the mediation table fails, not your case for court. And it gets misused. The pure meaning of the BATMA is if the table fails, if the mediation table fails, if the negotiation table fails. That's what that means. The ML in the middle, the most likely, what is the middle? It's the middle row. What's most likely going to happen for you when you walk on that door if this mediation table fails today? What's most likely? Sometimes I start in the middle with the most likely, then I go to the worst, then I go to the best. You can use all three of those as negotiation reality checking techniques, which typically get used in my mediation practice anyway, but they're also a negotiation tactic. But I already use them in the mediation process when I do the disruption. So I take that one out and I put it in, but these are all ways to tactically negotiate with people. And if you're going to split the difference between monies, like 50-50, you have to value the money before you can split the difference. The biggest mistake lawyers make at the mediation table, negotiation table, is they don't take the value over with the numbers. Lawyers take a number and go drop it down and drop it up, high or up or lower. That's only two directional. Money has more meaning than that. Money can be 360 when you take over the meaning with the money. Well, if we drop it 5,000, what categories? Pain and suffering, loss of consortium, loss of income. What categories are also dropping to make the $5,000 drop or the increase? What categories have increased? We take over all the meaning as facilitative mediators and the reasons why. We just don't leverage the duality of the high or low numbers. And then we meet in the middle somewhere. If you're going to split the difference, you have to evaluate what the 50-50 is, what the 70-30 is, what the 60-40 is. It has to be evaluated first. You can split the difference. People will split the difference if you give value to what they want. What is 30% and what is your 70%? So there's a lot to say about all of this, but that's a great question. Thank you for it.
Thank you so much, ma'am.
Mhm.
Do anybody have more questions? Please go ahead.
Ma'am, my question was, in a high conflict mediation, like what is the most effective strategy for desescalating emotions while like still keeping both parties engaged in a productive conversation?
Thank you for that. That's another fantastic question. Number one, my most effective tool is to interrupt. There are cultures, as your beautiful culture, where interrupting isn't always a respectful thing to do. At the mediation table, interruption is one of your tools as a mediator. When it starts to become highly escalated, I interrupt. Say, excuse me one moment. To interrupt, you have to speak faster than they are. In India, you're already speaking very fast. And you have to speak even faster. Excuse me one moment. I need to interrupt. I need to interrupt. Excuse me, Charu, I need to interrupt. Use someone's first name when you want to interrupt them. I want to interrupt. Very quickly, are you both comfortable talking to each other this way? That's my first question. Is everyone comfortable talking to each other this way? Because remember, I'm a facilitative mediator. I'm protecting the culture of them. You have a culture when you argue. You have a culture of you when you fight. You have a culture when you're discussing. You have a culture when you're frustrated. You have a culture of you. It's not your personality. It's your biology. That's the first thing I'm saying. Is everyone comfortable? If everyone says, yes, we're comfortable, I sit back. I go like this. I'm like, okay, I'm just going to take notes. And I say continue, or I say proceed. I give a directive. Proceed, continue, and I'm just taking notes. That's the first thing I do. So if everyone's comfortable, why can't they keep on talking? That's their culture under conflict. So that's the very first thing I do. If that,
Ma'am,
yes.
there is another question from Advocate Wasim. So he is saying that, are there any tried and tested standard techniques to overcome the impasse?
Yes. Well, to overcome impasse, we need to recognize what impasse is. I never use the word impasse because it creates, again, words in the air. It creates a chasm. I say, so thank you right now, because right now the mediation table has stopped moving. Impasse is movement of mediation stopped. And this is what I say to people. I say, thank you very much for loyalty to yourself as your mediator. You've been very consistent. I've heard it from the beginning of the mediation. And now the movement at the table has stopped. So first of all, I name it. I thank people, the gratitude tool, and then I name it. And then I say, if you want this table to keep on moving, you're going to have to relinquish your hold on loyalty to self. I call impasse loyalty to self. If you want this negotiation table to keep on moving, you're going to have to relinquish your hold on loyalty to self. As your mediator, I'll let you know when I need you to relinquish that hold. Or I'll say, whenever you're ready to relinquish that hold on loyalty to self, the mediation table can continue moving. So I describe the culture of the table rather than blaming the people at the table for their loyalty to self. Everyone's allowed to be loyal to self. And I'm going to ask, how is this loyalty to self going to advance the mediation table as well?
Ma'am, we have another question from Ashwant. So he said that, my question is that as a young law student from India who want to build an international career in mediation, what steps should he take and what step you recommend him in the early stage, such as training, certification, practice, experience, or mentorship to become a competent mediator?
The 40-hour basic training starts the journey of becoming a competent mediator. And that is available to YCM. I'm one of their outside assessors in India. You can take that Phoenix Dispute Solutions training. That is going to incur a cost. Every mediator has to take the 40-hour basic training across the world. And that's where you start. And then you find a place where you can practice your skills under a mentor. That's the second best thing to do as well.
This is Balagopalakrishnan from Hyderabad. So
Right.
in case of any technical arbitration with respect to any construction, very complicated construction contract, or any complicated IT projects, is there any benefit of doubts? Not normally always favors the vendors. I think so that so the award, it favors the vendor who is performing the job instead of the who is offering the job to the vendor. So it is the opinion formed that always contractors are given priority in case of any benefit of doubt. Is that true, or how to construe these kind of things in case of any complicated the contractual obligations and its failure?
So thank you for that question as well. Contractual obligations are usually aligned with industry practices and standards. So it's very important to have, every river has its banks. You have to have the structure. Remember, a process equals structure plus flexibility. You have to have the structure of, the construction industry and standards. And then you have to have the complaint of the other side, what's going on with that. So people have a right to file levy complaints against the breach of industry standards. So employers are powerful, but they're also aligned with the law. And it's important to get into the honesty and integrity, because especially in the construction industry, where I've worked a lot in Providence, Rhode Island, and a little bit in Boston, Mass. There's a lot of, in New York as well, there's a lot of ego. So if you undo that someone's done something wrong, you expose them as a person as well. It's very tricky business when there's a lot of high ego. And it's the same thing in the AI. You've got industry practices and standards in AI as well. If someone changes the AI program, you have to go back to the source coding. So it's always back to the industry standards and practices where I align the structure of my mediation, and then we move out from there. I hope that's helpful.
Thank you so much, ma'am. I would now request Mr. Sunil to kindly share his words of gratitude. Sir, we would love to hear from you. The floor is yours.
Thank you so much for the opportunity, ma'am. And ma'am, I would say that listening to you was, I was like dumbstruck. The decade experience you shared in these couple of moments, I had so many golden nuggets that I could absorb. But two things really stood out for me for today, and I think it just made my day when you said that as a mediator, we do have the agenda, we do have the decisions that the party has made, but then we act like disruptors. So that was amazing. That was something very, very different that I've heard from a seasoned mediator. And the second thing that really stood out was when you said justice has a feeling. That was like too deep for me to understand, and it was something that I'm gonna cherish, and I'm gonna take these things with me and become a better mediator. But I really loved your session, ma'am. Thank you so much for sharing your decade-old knowledge and experience in these few minutes. I enjoyed it thoroughly.
It's my pleasure, and thank you for your kind comments. I appreciate them. I hope everyone had a great time. Much love, and let's advance mediation. Take care.
Yes, ma'am. Thank you so much for sharing your time, sharing your experience, and sharing your exceptional wisdom with us today. Your insights into mediation, your insights into conflict resolution, and the practical skills were much needed for all of us, and they were truly enlightening. The clarity and compassion with which you spoke made the session truly, deeply impactful for all of us. Your journey continues to inspire young minds like us and future mediators, and we are privileged to have you, ma'am. With much love from India. Thank you for connecting with us across borders and making this session memorable and meaningful. We look forward to many more such sessions. And yeah, we will remember, justice is a feeling. I request everyone to turn on your camera and say hi to Miss Kathleen so that we can have a group picture together.
Yes, let's do that.
I request Miss Shalini to take a picture from the laptop itself, and everyone please switch on your camera.
Hi, everyone. It's nice to see faces. Hi.
Hi, ma'am.
Much.
Thank you, Rita. Thank you.
Ma'am, much love from India.
Thank you so much. Bye-bye, everyone.
Amazing.
Thank you, ma'am.
Have a nice day.
Wonderful.
Thank you so much.
There you are, Amrush. How are you?
Great, great, great. I've been
Everybody.
this session and it is
Thank you
really
so much.
insightful.
Good. I'm glad. Glad to help. Happy to help.
So we have Mr. Amresh, the founder of Into Legal World.
Mm-hmm.
Warm welcome to
I
you, sir.
know about him. What a great guy. Mhm. All right,
Thank you.
everyone. Bye-bye. I'm going to go work out in the gym.
Oh,
Bye,
that's great.
ma'am. Do take care,
Bye.
ma'am.
Bye.
Hi, everyone. Thank you so much for attending the session.
Very interesting
Thanks
indeed.
to you too, ma'am.
Thank you so much for getting her on board. It was really nice.
Yes, ma'am. She was really awesome.
She was, and she really brought out such insights which, otherwise go
And
unattended.
she has decades of experience on, and also she is a professor with Harvard and many more universities. So it was just reflecting on her face and her knowledge.
It's so nice to, look at things from such a different perspective. Really
True,
good.
true.
Thank you so much.
Our
Thank you.
pleasure, ma'am. Please stay connected with Into Legal
By the
World.
way, she was involved in Amazon case as well. I mean, she has taken a very, very big case these days. And her colleague, lecture was taken by
Geo, sir.
Leonardo.
Mhm.
He is his colleague. They have a firm called International Mediator. And I was thinking that David sir can also be in the session, but he is busy traveling around the world. He is currently in Switzerland. So next time, if he would be free, he'd be in the session. Thank you, everyone, guys, and it is really wonderful. I remember Rita ma'am from RERA course,
Yeah.
right?
Radar,
And here we have
PMLA,
a
We
PMLA
have,
also.
yeah,
PMLO,
yeah.
PMLA as well, right?
Yes. And I'm
Right.
so
We have,
happy you are doing such good work. I
Thank
we
always
you.
also
look
Thank
have,
forward to anything new that's happening. It's good to keep upgrading yourself.
Right, ma'am. And I myself teach ADR, but reading out and hearing to these lecture surely give me a good perspective. We were discussing in the group itself that we should make a quotation of certain line that ma'am is saying, and certainly we'll be working on the video and we'll be uploading it on the YouTube, and we'll be uploading it around.
It's been an interesting journey for me also with
Right.
into legal world. Lots of different topics have been taken up, and it's like you keep upgrading your own knowledge all the time.
Right. And our all of the courses are maximum range is 2,500 to 3,000. So it's really wonderful that anyone can, take in the session without being burden on their pocket.
Yes,
It's yeah.
I appreciate the concession I get because I attend all your almost. But nice meeting all of you. Very nice. And
yeah,
please
yeah.
keep on the good work. Very nice.
Yes, ma'am.
Thank
We
you, ma'am.
will.
Thank
Very
you.
enjoyable. Thank you so much and good night.
Thank
Thank
you
you.
so much,
Thank you
ma'am.
everyone for
Bye
being in
bye.
the session.